Good morning, everybody, and a very warm welcome to you all to our virtual employment law seminar. We hope you can find today's information we're going to present to you helpful and supportive, but do remember our team are always here to support you moving forward. We've got a mix of clients and non-clients on the call. There's people here who we've done project work for, who have got to retain a contract with us for HR consultants, who have advice line services or access to our knowledge base, have used our e-learning system, or have used one of our payroll recruitment and HR admin services as well. So a complete range of people who we've met before or not met before. So welcome to those of you who are joining us for the first time. It is great to have you here with us. So my name is Sue Watson, and I am the Head of Client Services at HR Solutions. So look after the client delivery team here. I'm joined today by Helen Astle. Many of you will know her from Cherrington HR, who are now part of the HR Solutions family. And for those of you who have joined our previous webinars, you may have been expecting Victoria, one of our knowledge managers, to be present today. She had planned to be here, but unfortunately has COVID, so is not well enough to join us today. So Helen and I are going to take you through the topics. In support today, we've got Rebecca and Drew. They are here to help if you have any technical issues. Hopefully you won't, but if you do, then send a message through the chat facility. More on that next, and they will try and help you. A copy of the slides and a link to the recording of today's event will also be made available to you afterwards. So we do encourage you to ask questions, and this is some guidance on how to do this. We've had to put you on mute today because there's so many of you on the call, so it will become very difficult. So this is how you ask questions. You should have a chat panel, something like this. And if you click on the question, you should be able to post your question to the staff here. We will then collate the questions during the webinar, and when we come to the question section at the end, we will discuss them out loud for you. We want to make this session as interactive as we would normally at our physical events, so we will be running a series of polls throughout the session as well. When we have a poll, it will appear on your screen like this, and you just select the answer that is appropriate for you. We're going to start with a couple of short polls as a warm-up for you. So the first poll I'm going to load is, would it be useful to understand who our audience is today? So we're going to ask you, what is your current role? So I'll just load that poll for you. Poll is now open, so tick on whichever one is appropriate. I think the votes are coming in thick and fast, I can see that. Okay, I think most of you voted now. So I'm going to close that poll and I'll share the results with you. So we've got most of you are in HR, but we've also got a significant number of business owners and line managers with us here today. So anyway, welcome to all of you. We hope that you'll all find something useful and a snippet that you were not aware of or were interesting to discuss with us. And we also welcome your views on some of the topics that we're going to discuss. So I'm going to hide that poll and I'm going to launch our second poll. So it's whether you've attended any of our seminars before. So that one's open now. I'm going to close that poll. So that's interesting. So there's quite a good number of you who haven't actually joined any of our events before. So a very warm welcome to you all. And I hope you will find this interesting. You'll discover as we go through, we do cover a wide range of topics regularly every month. And but this is an annual event that we hold, which is a full employment law update. So it's a little bit more focused on cases and legislation. Okay, I'm going to there's the results for you. Okay, let's move on. So let's move into our employment law seminar itself. So this is a summary of the topics we're going to talk about today. So I'm going to initially cover some of the recent changes, some important case rulings, recent changes. Then Helen's going to talk about important case rulings and tips from the tribunals. Then we're going to have a look at some of the current employment legislation and some that's likely to come in during the rest of the year. We've also got a section on supporting the Ukraine crisis following a number of queries through our helplines and through the team. And then we'll end with you ask us. So you can ask us any question you like. And it's probably better that if it comes into your head, a question you'd like to ask us, then put it through the question panel as soon as you think of it, because we'll collate them during the seminar and then we will ask them at the end. So let's look at recent changes. So we're going to have a quick look at some statutory rate increases, just briefly, just to remind you of them. And then we're going to look at coronavirus and where we are now. There's quite a few different queries coming through on that. And then the changes to the immigration rules. So the first one is the national minimum, the national living wage, which are both going to increase in April to the new rates shown on your screen now. Just as a reminder, the national minimum wage and the national living wage are essentially the same. The government, for whatever reason, decided to define the 23 plus level as a national living wage, which confused quite a lot of people because we have the real living wage as well, which has nothing to do with it. It's a completely separate figure as well. So it just defines the minimum pay rate for a certain age group, basically. The national living wage is what we're obliged to pay for those who are 23 years and above. But you can see all those rates there, and there's a significant increase this April, which is what's also causing a lot of challenges as you've budgeted, I'm sure. So the other statutory rates that are increasing are for SSP, for all the family-friendly rates, as well as statutory guarantee payments. So there are increases for all of those, as you'll see. Just note the different dates because of the way you apply them through payroll, but the most of them are from the 6th of April, but the SMP, SPP, the adoption pay and the paternity pay are all from the 3rd of April. The statutory guarantee payments, which is what an employee will receive if you need to temporarily lay them off, will rise from £30 to £31 too, but they haven't yet confirmed this on their website at the moment. So, but they would receive £31 a day for 5 days in any 3-month period. And then we've got the redundancy and employment tribunal awards for dismissals on or after the 6th of April. So if you are going through a redundancy process at the moment and the dismissals are likely to take effect after the 6th of April, on or after the 6th of April this year, then remember you'll need to recalculate their week's pay based on £571 a week max, and therefore the maximum compensatory award they could receive if there was a successful unfair or constructive unfair dismissal case will be £93,878 from the 6th of April. And then we've got the health and social care levy from the 6th of April. So this year, because they haven't got the technology in place yet, they're applying a 1.25% rise to national insurance contributions. And this will apply to employees and the self-employed, although it doesn't affect anybody over the state pension age until next year. Next year, the national insurance levels are going to revert to current levels, and then they're going to bring an additional levy in place of it for the 1.25%. So it will show as a separate health and social care levy. But because the technology wasn't in place for them to process it this year, they've just applied it as an increase to national insurance contributions. I think it's probably unlikely that the government are going to delay this further. Rishi has indicated he's not going to. But we'll wait for the budget this afternoon to hear whether or not he decides to increase the limit above which you will pay. So we will see whether he does it that way or whether it just continues as is now. So then let's move on to COVID. Unfortunately, there is no escaping coronavirus, and who would have thought 2 years ago that we'd still be living in a pandemic now? And that is the key difference. We are still in a pandemic. It is very much worldwide and still spreading. So that is why it is still being treated separately to, say, the annual flu virus, which is endemic. So that's kind of the difference in why it's treated differently and why there are more stringent processes to follow. So we know recently we've had the responsibility moved away from government and onto employers and individuals to manage COVID. We no longer have a legal requirement to self-isolate, but it still remains government advice. And those who are double vaccinated do not need to pass a COVID test before arriving in the UK. And then from April, we've got the removal of the legal requirement to explicitly consider COVID in your risk assessment, but more on these later. And we've also got the removal of free testing for the general public with limited testing for certain at-risk groups. So, and that's from April as well. So, you know, they are passing the responsibility onto you as employers and us as individuals to help manage it going forward. But we're going to look at some of those in a bit more detail shortly, because, you know, what has changed for us as the end users and where the impact is from an employment perspective. So what does it mean? So the government continue to encourage us all to advise and adopt safe working practices. And health and safety legislation still remains the only legal framework for managing workplace risks associated with COVID. So just because the government have removed legal requirements, it doesn't mean we can ignore it or we can soften our approach. Our legal obligations are to protect the health, safety and welfare of everyone in the workplace and to make appropriate arrangements to ensure this. This duty extends to those who may be affected by the business, visitors, contractors, agency workers and customers. We also have an obligation to identify causes of illness in a business, decide how somebody could be harmed and how seriously, and take action to eliminate the hazard or control the risk if not possible to eliminate. And finally, it's a criminal offence where there's been a failure to take all reasonably practical steps to reduce workplace risks to their lowest level. So when you consider those that are in place, and they have been in place all along, you can see why as employers, as businesses, we need to really still seriously consider our approach to managing COVID particularly while it is still a pandemic. So even though the COVID risk assessment is no longer legally required, your usual risk assessments must still consider workplace risks, which will have to include COVID. You need to give consideration to those who are clinically extremely vulnerable and all those who are pregnant. And of course, the Equality Act places a legal obligation on employers to make reasonable adjustments, and measures could constitute reasonable adjustment for some employees. And what about mandatory vaccinations? Well, it's very topical and very risky. Is it discriminatory? When you apply a policy or practice to the whole workforce, yet it puts a group of employees at a disadvantage because of a protected characteristic that they hold, then it becomes indirect discrimination. But there can be certain circumstances whereby indirect discrimination may be lawful, but it's a strong threshold. So basically, there needs to be a legitimate aim for introducing the policy or practice. And secondly, that policy or practice has to be a proportionate means of achieving that aim. In other words, there isn't any other less discriminatory way in which you can achieve that aim. So of course, that's going to be risky on many levels. So you need to be absolutely clear that you really have a strong basis for introducing them. The government had introduced mandatory vaccinations, and we're going to discuss the kind of withdrawal of that shortly. But they changed their mind because they no longer could state it was a proportionate means of achieving the aim of reducing the spread of the virus. So that's why you have to give serious considerations to any measures that you do take. And there are also risks surrounding the issue of a right from interference to a private life, which is Article 8 under the Human Rights Act. This hasn't been tested in the courts, but as a society, we don't force vaccinations onto people, so it still remains for the individual to choose. So you may feel it's advisable to have a policy in place so that managers and employees know exactly the expectations and rules in place for ensuring workplace safety. If you do decide to have a policy, it should set out its scope and purpose, which is really to stop transmission of the virus and to protect the safety of your employees and all those affected by your business. And it should be clearly setting out responsibilities, both from a company's perspective as well as the employee, as they too have legal responsibilities to comply with reasonable steps in place to manage the risks. We would also advise setting out how you will support those who are at high risk from the virus, so those clinically vulnerable and pregnant workers. So, time for another poll. So I'm just going to move on. So the first poll that we're going to load is, can you require staff to return to the office full time? I think just let one or two more vote. Okay, I'm going to close that one and I'll share the results with you. So 89% of you said yes, you can, but there are 11% who said no. So the answer is kind of yes, potentially. There is no longer government advice to do so, or to remain working at home. It is for the employer to determine if it is sustainable to continue, and it could be a reasonable adjustment if working from home supports a disability. So you need to consider all aspects when employees say they can't return to the office full time, and whether or not you need to consider them remaining at home, and that is a reasonable adjustment, depending on the reason why they can't attend the office. But in many cases, you can require them to return to the office, but then bearing in mind any health and safety risk assessments you've undertaken to ensure you protect them when they are at work and reduce the risk of them contracting it at work or spreading the virus at work. So just linked with this, on the same sort of theme, let's look at the next one, which is, can you make employees wear face coverings around the office? to launch that one. Let's see what you think, that one. Okay, I think most people have voted now, so I'm going to close that and share those results. So 76% have said no and 24% yes. That's quite interesting because potentially you can. So employers are bound by health and safety laws, which means you have to take all reasonable practical steps to reduce workplace risks to the lowest level and put in place measures to mitigate risks. So a policy could set it as a requirement or optional. And any policy you have about wearing face coverings must be fair, reasonable and proportionate and be based on the circumstances of each business. And also considering the different demographics of your workforce, if you've got any clinically extremely vulnerable and pregnant workers. So if you are working in an office that is quite small and quite confined, you may feel it is a reasonable and proportionate means of minimizing the risk to employees in the office, working in the office, but you have to consider your own circumstances. But so potentially it could be a reasonable means of minimizing risk. So our final poll is we're going to look at, can you require employees to self-isolate if they test positive? Notice the words require. Can I require employees to self-isolate if they test positive for COVID? Okay, I'm going to close that poll and share the results. So we've got an overwhelming yes, and you're absolutely right. Employers are entitled to introduce rules and procedures appropriate to the workplace that are fair, reasonable and proportionate. We remain in a pandemic and COVID is highly infectious, and vulnerable and unvaccinated are at a greater risk from serious harm. So, and it's essential that you have a policy that mitigates against the risk. So therefore it would be likely to be a proportionate and reasonable response to require employees to self-isolate if they test positive. Obviously it gives some challenges because if they are positive and not showing any symptoms, that's a different challenge to if they are positive and show symptoms and are unwell. But clearly it is a reasonable response. Just going to hide that. Okay, let's move on. So what's next? So what's next for COVID first? So we continue to be in a pandemic, so we have to continue with working safely with COVID. We have to be prepared for new variants. I think we've got at least 2 new ones going around at the moment. And we have to consider if there's going to be any future restrictions depending on what happens with the new variants. We have drafted a policy which gives some suggestions and ideas about what you might want to implement for working safely with COVID, both from a sort of HR and a health and safety angle. And that's available on our doc shop, or if you are a client, you're via the knowledge base, or your consultant, if you're interested, just ask us for it and we can make that available to you. What's next? In terms of immigration rules, so the points-based immigration system came into force on the 1st of January 2021, requiring employers to become sponsors when they're recruiting from outside the UK. Thankfully, this year, it's seen the job of care worker and home carer added to the skilled worker eligible occupations list. This should help enormously with the huge challenges we've had in that sector of recruiting staff. We've got a number of clients in that particular sector, and I know it's been really, really hard, and so thankfully, finally, they've added them to the skilled worker, so we can widen the net of candidates for vacancies. And then more recently, we have the update to the visa entry for an emergency visa for Ukrainian refugees, for which there are 2 routes, which you're just going to look at. So we have the family scheme visa, and that applies only to those who can join family members already in the UK. They can live, work and study in the UK and access public services for up to 3 years. But the UK family member must be immediate, extended or an immediate family of an extended family member. So that's the first route in. And then we've now got the new one recently announced of the Homes for Ukraine Refugee Scheme, which is a visa sponsorship scheme sponsored by an individual or an organisation. And that provides accommodation for at least 6 months. Charities, community groups and churches can help with matching refugees to a UK host where the refugee has no known UK contact. This is a national effort where organisations can work with charities, faith groups, councils and communities to provide the support short and long term. And their funding has been provided to local authorities to provide wider support to families to rebuild their lives and to integrate into the community. So Ukrainian nationals under this route will be able to work, receive benefits and access education as part of the visa. Some UK businesses have launched an initiative to make it easier to offer employment to them. And there's a recently launched jobs board, jobsforukraine.net, aimed at supporting Ukrainian refugees. And we've got a bit more information on Ukraine later. It's some options for employers to help support. And then we've got the right to work checks. As you'll be aware, the emergency right to work checks due to COVID were extended until the 30th of September 2022, which enables you to carry out right to work checks via a video call and use scanned or a photograph of documents of the original accepted. And you can also go online and work through the checks with the individual. They've now introduced a new digital identity document validation technology, IDVT, and because of the success of the right to work checks being carried out remotely and the number of companies deciding to remain working remotely or virtually or using some kind of hybrid or just recruiting people from more remote parts of the country. So they've the Home Office reviewed specialist technology to further support this post-pandemic, and from the 6th of April they're going to provide employers the support of a certified IDVT service provider. So at the moment there's a number of service providers getting set up to be able to carry out these digital checks, and once those are in place we'll be able to upload images of personal documents, and it will allow private sector service providers to become independently certified by the UK accreditation services, which will make sure that the technology meets the government standards. So they're widening the net and enabling us to continue with some kind of digital checking process, which is all good. So I'm now going to hand over to Helen, who's going to take us through some important and interesting case rulings and also some tips from the Tribunal. So let me just hand this over to Helen.
Hello, can you hear me?
Yes, we can hear you.
Hello, everybody. Good morning. I'm Helen Astle, and as Sue explained earlier, that I have joined HR Solutions family, although still running Cherrington HR. So it's a little bit of a sort of combined effort this morning. And what I'm going to talk to you about initially, there we go. Right, so COVID tribunal cases. Now, interestingly, when it comes to COVID tribunal cases, so far, we only have employment tribunal rulings. And for those of you who are not familiar with the way the court system works, the first rung, if you like, of the process is somebody goes to tribunal. Now, if those cases are decided, they're decided on the particular case details. That means any ruling that comes out of that is not necessarily binding on any other case. If it gets to the appeal tribunal, then it does become something that other cases can rely on as being something that has been determined. So at the moment, it's too soon to have any appeal cases or any cases that have gone higher through the system to, for example, the Supreme Court. We haven't got that far. So these are just indications of the way in which the tribunals are thinking at present. And I'm going to look at 4 in particular: Rogers versus Leeds Laser cutting. Some of you may have come across that. One excitingly called X versus Y. One against Tax of Scotland Limited. Tax of Scotland, if you're not familiar, is a retail clothing brand that shops. And the last one, Loving Angels, is a care provider. So we'll have a look at those because they look at different aspects of the rulings. So I'm not, there we go. Right, so as I've said, they're not binding, but they do give an idea of the issues being addressed. And panels have been trained to deal with COVID issues. And I know this because I sit on some of the panels. And we're looking at things like, are people being discriminated against, perhaps on grounds of religion and belief? Are they whistleblowing cases? Are they cases that look at dismissal? Are people being perhaps unfairly picked on from a redundancy point of view, and also family-friendly rights? So these are the sorts of things that tribunal members have been trained to look at when it comes to how they've been treated with regards to COVID. So the first one, Rogers versus Leeds Laser. This is an interesting one because we've got Mr. Rogers, who was, he started working in a warehouse in 2019, and the area he worked in was described as being the size of half of a football pitch, and there weren't many employees. And generally, he would work with about 5 other people. But in early 2020, just before the first coronavirus lockdown, which you may remember was actually announced 2 years ago today, one of his colleagues displayed symptoms of COVID-19, and he was sent home to isolate. Now, the warehouse remained open because it wasn't on the list of government workplaces that needed to close. You may remember they issued a list of businesses that weren't allowed, sectors that weren't allowed to trade, but this one was okay. The organisation put mitigation measures in place to help stop the spread of the virus. These included things like social distancing, regular cleaning of workstations, staggering start and finish times, and they also had face masks, which they could use if they wanted. Now, 2 days later, the claimant self-isolated because he had a bit of a cough. He was unable to get a test for COVID-19 because, if you remember back then, you could only get a test if you were actually in hospital. So he just thought it was dust in the warehouse. He then sent a text to his line manager informing him he was going to stay off work until the lockdown had eased. Now, you may remember we all thought it was only going to be for 3 weeks at this point. He didn't want to risk bringing COVID home to his children, one of whom had sickle cell anemia, so was therefore quite vulnerable. And the manager replied to the text with the words, "Okay, mate, look after yourself." And that was about it. There was no further communication between the claimant or the employer until the 24th of April. And on that date, he discovered he'd been dismissed. So they hadn't communicated with him. He just discovered he wasn't employed anymore, and it was unclear as to why. So as a result, he brought a claim to the tribunal for automatic unfair dismissal. Now, he did this on the basis that his reasonable belief that the warehouse posed a serious and imminent threat to his family's health. This is what we call a Section 44 claim. He couldn't have brought an ordinary unfair dismissal claim because he hadn't had 2 years of employment service. So he didn't qualify to do that. So instead, he's relied upon the Section 44 health and safety ruling. So we end up with the situation as it goes to the tribunal. But they dismissed his claim. They carefully evaluated whether the claimant actually had a reasonable belief, as outlined in the legislation, that his health was at serious risk, serious and imminent, remember. They did accept that he had significant concerns about the ongoing pandemic, and in particular, he was concerned about how this could impact on his children should they catch the disease. But despite that, they called into his actions. There were other details. For example, it was accepted that on one occasion he got into a car with somebody else. Remember, you weren't allowed to travel with members of other families or whatever at the time, to give his mate a lift in the car. So one of the things the tribunal said was, well, hang on a minute, if he's actually that concerned, why has he broken the other rules? Is he just going to pick and choose? So the claimant, quite crucially, had failed to specify to his employer why he felt the workplace was unsafe. He just said, it's unsafe. He had only outlined his intention to remain at home until lockdown has eased, and he'd refused to come into the warehouse. This was despite agreeing that he would have been able to socially distance. He also failed to demonstrate why the other measures they put into place would keep him safe, and that they didn't go far enough. The tribunal considered what he put forward was vague and contradictory. In fact, at the time, the government guidance was limited for workplaces that could stay open. Remember, they were making it up as they went along to some extent. The guidance told staff to work from home if they could, but if they couldn't, employers must take steps to allow staff to keep their distance and wash their hands. And that was pretty much it at the time. From what the tribunal could establish, the claimant was able to do both of these things, and he hadn't said that he couldn't. However, what they didn't like was the issue with regards to how he was dismissed, because basically he just suddenly discovered he wasn't employed anymore. And they said, had he had sufficient service, had he been employed for 2 years or more, and he'd brought an unfair dismissal claim, it is quite likely that he would have succeeded in doing that. The thing to remember about these cases is that when a tribunal looks at them, they will look at the circumstances and the rules that are in place at the time the decisions were made. And a lot has happened over the last 2 years, so sometimes that can be quite tricky to remember what the rules were at that time. But it's taking a couple of years for some of these to get to tribunal, so they will need to look back at that. So now we will move on to the case of X versus Y, and this one relates to a claim under the Equality Act with regards to the question of whether the fear of COVID is a protected act. So in this one, the claimant decided not to return to the workplace in July 2020 due to concerns about catching and spreading COVID-19, and in particular to her clinically vulnerable partner. So we've got a bit of a theme here, people being worried about family members. Now, the employer, who we've named as Y in the case, withheld her wages while she remained off work, and she raised a complaint of unlawful discrimination because she felt this was against her protected characteristic of religion and belief. Now, obviously COVID isn't a religion, but she had a strong belief, a fear, she said, of catching COVID-19 and a need to protect herself and others. So the tribunal had a preliminary hearing to determine whether that belief amounted to a protected characteristic under the Equality Act. Now, all of these criteria are quite important. So there are 5 limbs they described as tests for whether a philosophical belief has been established in case law. So firstly, the belief must be genuinely held. It mustn't be just a vague notion. It must be a belief, not an opinion or viewpoint based on the present state of information available. It must be a belief. It must be a belief as to a weighty and substantial aspect of human life and behaviour. It must attain a certain level of cogency, seriousness, cohesion and importance. And finally, it must be worthy of respect in a democratic society, not be incompatible with human dignity, and not be in conflict with the fundamental rights of others. So it's quite a lot. When the sort of bit about substantial aspect of human life and behaviour, they have had other cases, for example, where people have said, well, I'm a vegetarian, and that's a philosophical belief, and tribunals have thrown that out. But if you had somebody perhaps who is a vegan, who structures their life around not harming animals and so on, and it forms a central pillar to the way in which they live their life, then that would be considered different to somebody who's just made some diet choices. So the thing about all these five is you can't just pick one or two of them. All of them must be in place for a belief to be established. So it's actually quite a high hurdle to get over. And what we have here then is what the tribunal found. They said it did not meet the second and the third of those tests that we looked at just a moment ago. The second one, the claimant reasoning, they said, did not amount to a belief. Rather, they said it is a reaction to a threat of physical harm and the need to take steps to avoid or reduce that threat. Now, most, if not all people, instinctively react to perceived or real threats of physical harm in one way or another, but that does not, in the tribunal's view, equate to a belief for the purposes of Section 10 of the Equality Act of 2010. The third limb are the ones we looked at before. The tribunal accepted that the belief was indeed weighty and substantial, but it still found that this was not met because the claimant's reasoning related to her own narrow circumstances and was not a belief in the wider terms. It was just about herself and protection of herself and her own step to protect others. It wasn't a belief that applied more widely. So the case looked at a very narrow question in an individual set of circumstances, and employers will need to consider each case on its own facts, exploring that employee's particular reasoning and circumstances, and bearing in mind the employer's wider legal duties, including the Equality Act, but also under governments working safely with coronavirus guidance, health and safety law, and other relevant legislation. Now, remember that the legislation is changing in terms of the coronavirus bits going forward, but we're still looking at cases that have taken place under those rulings. So now let's look at this Scottish case. Although England and Wales have slightly different employment legislation to Scotland, and of course the rules with regards to coronavirus changed at different times, it's likely that this case is likely to be treated very similarly in England and Wales. And so it's a more recent case as well. So in this particular instance, an employee was furloughed and her pay reduced to 80%. Remember furlough? But this was done without her agreement. And again, if you remember the furlough arrangements, you had to get an employee's agreement to the fact that you were going to reduce their pay. But she was also a disabled person within the meaning of the Equality Act because she was having treatment for cancer. Now, in some cases, you will be aware that a disability is something that's only determined by a tribunal, although you can often reasonably have a good guess as to whether somebody is categorised as having a disability or not. There are some illnesses that are automatically qualify somebody for being categorised as having a disability, and cancer is one of them. And then in this particular one, the employee and other staff complained to the chief exec of the company that they were being required to work whilst claiming furlough. So we have a fraud element there. there was non-compliance with the COVID guidelines that were in place from the Scottish Government at the time. And they also complained there was a failure to take steps to provide a safe working environment to protect the health and safety of staff in relation to transmission of COVID-19. Now, the employee was then dismissed, and she claimed unlawful deductions from wages, breach of contract, failure to pay notice pay and accrued holiday pay, and not being provided with a statement of terms and conditions of employment. Employees can only make that claim, the bit about not having contracts and so on, if they, if you like, piggyback it on something else. They can't make a separate claim to a tribunal on that front. She also claimed she'd received detrimental treatment for making protected disclosures. So this is a whistleblowing case for health and safety reasons, and dismissal for raising health and safety concerns with her employer and or for making a protected disclosure. Now, neither the employers, the company, or the chief exec submitted a defence. Neither did they attend the hearing. Not quite sure why. Perhaps they just didn't really take it seriously. So we're going to look at two different things. Firstly, the bit about the unlawful deductions. They found there'd been unlawful deductions for wages and made a payment order to cover those. In addition, so this was the sort of the fact that the 80% had been paid rather than the full amount. So compensation was also due for lack of notice pay, accrued holiday pay, and failure to provide that written statement of particulars. Now, in addition, her detriment claim succeeded, so she was also due compensation for dismissal on the grounds of making protected disclosure of just over £18,000. That's quite a lot of money. It included injury to feelings and interest, plus compensation for ongoing financial loss for 52 weeks. She had managed to find herself alternative employment, but it was on a lower salary and benefits, and there were additional travel costs. So the difference there was required to be paid. The fact that her health was part of this as well increased her compensation, because her employer should have known that failing to address the COVID-19 health and safety concerns put her in a potentially life-endangering situation, because she was required to work without any protective measures in place. And the impact on the claimant was exacerbated by obviously trying to find alternative employment during a pandemic. It wasn't going to be easy to do. So we then get the whistleblowing element of this. As I've said, £18,000, and I think it shows quite an interesting approach. If you remember, I said neither the company nor the chief exec turned up to the hearing. If you have a look at Glassdoor, and I know these comments are always completed anonymously, I did notice there was one posted the other day saying, well, they're really lovely people to work for, but absolutely rubbish employers. So there obviously seems to be a trend there that they're not really interested in their staff. So let's look at this next case here. Now, this one relates to a form of a claim of unfair dismissal from an employee who said that the employer could have furloughed her instead. Now, we don't have the furlough arrangements anymore, so this one is a little historic, but it's an interesting situation, because what we're looking at here is that thinking about what the furlough scheme was for, it was to help, if you like, businesses tide things over until they could trade properly again. In this case, the employee was made redundant very early in the months of COVID-19, and she says she was unfairly dismissed because her employer hadn't considered furloughing her. Now, the claimant worked as a care assistant providing live-in care for an elderly woman until February 2020. So remember, this is before lockdown, and the lady was moved into a care home. In May 2020, she asked to be furloughed. This is the claimant. And her employer refused on the basis they couldn't offer any more live-in care work due to the restrictions imposed to control the spread of the virus. But remember, the furlough system was there to tide businesses over. But in July 2020, she was dismissed for redundancy, and she brought various claims one of which was unfair dismissal. So the unfair dismissal claim was upheld. And the reason for this, the main reason, was that the judge said that in July 2020, a reasonable employer would have given consideration as to whether the employee could have been furloughed to avoid being dismissed on the grounds of redundancy. Her employer had no live-in work available and could only offer her domiciliary work, which wasn't suitable because of travelling involved. So the judge said this was exactly the type of situation that the furlough scheme envisaged. Why it was not considered or not considered suitable in this case was not explained by the employer. And although her employer had no work for it at the time, it had no way of knowing if that was going to change, and it didn't consider whether she could be furloughed for a time to see if anything else could be available. So it's not the fact that she was dismissed, it was the fact that they didn't consider it and come up with a reason as to why it wasn't going to work. There is a difference between an employer who says, I considered the furlough scheme but discounted it because we knew we were no longer doing that work, and one who said, I did not furlough my employee because I did not know what the future would look like with COVID. The former is likely to be fair, the latter, based on this decision, likely to be unfair, because that was the whole point of the scheme. So those are some interesting COVID cases, and what we're going to look at now is a couple that are, well, likely to be of interest to you as employers. The first one is the Harper Trust and Brazel case. Now, this involves a lady who was a part-time music teacher. I think she taught saxophone. And this one's always been interesting to me because I have my younger son actually is a peripatetic saxophone teacher as well, so there's some similarities there. It was originally brought by Miss Harper and the Incorporated Society of Musicians, the ISM, but because it involved people who were teaching on a term time only basis, Unison thought that actually this was quite an important case for them to get involved in as well, because they represent a lot of people who work on term time basis. It's a case that could have significant implications for businesses with respect to managing holiday entitlement. And the reason being is that traditionally, many of you who've used a sort of irregular workers arrangement might calculate annual leave on the basis of 12.07%. And that was used to calculate her entitlement for working 10 to 15 hours a week during term time only. So basically what they were saying was, we're only going to calculate your annual leave on the basis of the fact you work 39 weeks a year or whatever it was, but average then over the year. And she brought this case because she said, well, that's not fair. I should get the minimum of the 5.6 weeks per year, which is normally equated to either 28 days for full-time workers or 20 days plus 8 bank holidays, however you work it out. But what the Harper Trust, which runs a private school, had done was saying, well, actually, you only work for a proportion of the year, so we're going to work out your leave proportionately. Now, if you've got somebody working part-time during a week, 3 days a week, you'd say, well, you get 3/5 of a week, but that's for 52 weeks of the year. If you look at the part-time workers regulations, it says that you are not supposed to disadvantage somebody who works part-time. And so normally people prorate things. What it doesn't say is that you can't be more generous, because people were saying, well, if you're working 39 weeks a year and you're getting 5.6 weeks of leave, that's more advantageous than if you're working 52 weeks a year and you still get 5.6 weeks. The regulations don't say that you can't be more generous with part-time staff, it just says you can't treat them worse. So this was the problem. So, okay, so she was engaged on a 0-hour contract, employed all year round, and that's the key bit. She was an employee for the whole year. She just worked some of it. They changed their method for calculating holiday pay in 2011, and this is how they did it, 12.07%. And she felt that she was actually worse off than she was now. So the Employment Tribunal actually found in favour of the Harper Trust, said, yes, you've done it right. She appealed. The Appeals Tribunal found in favour of Ms. Brazel. They've said, no, she's absolutely right. It should be 5.6 weeks. The Harper Trust appealed to the Supreme Court. That went in November 2021, and typically judgments come out 6 to 9 months after the hearings. So within the next 4 or 5 months, we should find out. So where does that leave us in terms of actually working out what you should do now? It's a difficult one because technically speaking, as the law stands, because the Appeal Tribunal has said Ms. Brazel is correct, if you have employees that are employed, have contracts for 52 weeks, you should give them a minimum of 5.6 weeks per year. Now, some employers are saying, well, I'm not going to change it just yet. I'm going to wait until the Supreme Court actually gives their final ruling. But if that's you and that's what your solicitors have advised, then make sure you've got some money put to one side, because you may need to make corrections and back pay if the current ruling is upheld. Difficult to say which way it's going to go, but I think personally, I think it will be upheld because there's nothing in the working time regulations and so on and part-time workers to say that actually she should be worse off. So that's where we get to on that one. So at present, the legal way of calculating is to give every worker a minimum of 5.6 weeks, whether they work part years or not. Key is to whether they're employed for the whole year. And as I've said, if you're still using the old version, then keep an eye on this one for when the decision actually comes out. And now we move on to one that's quite well, hot in the news, really. Today, P&O have said, we believe we've acted legally. And the reason for that is they say that actually the mariners were employed through 3 P&O companies based in Jersey. And therefore what they've done is entirely legal. Whether that's true or not, I think you probably all agree that it's probably not the right way to dismiss somebody. So the sort of issues that we're looking at here is that the consultations should have been, under UK law, for at least 45 days. But it depends on the size of each establishment. Were they counting one of these ships, one of these ferries as an establishment? And how many people on each ship was going to be made redundant? If it's 100 or more, then they should have had at least 45 days. If it's between 20 and 99, then we're looking at 30 days. So were they really redundancies? Because actually they're posts that are made redundant. They're saying they're just going to backfill them. So, where is their employment regulated? Is it Jersey? Or remember that mariners actually have different employment legislation to the rest of us. So there may be some quirks in there that we're not quite aware of in terms of the way they've done this. Remember, we're dealing a lot with rumour and things reported secondhand, so we don't have a first-hand knowledge of exactly what happened. However, P&O actually considered themselves to be close enough to the UK to actually claim furlough grants of £10 million. So there may be an argument that actually their contracts of employment were considered to be UK contracts. Replacement with much lower paid staff, agency staff, that is rumoured at £1.81 an hour. That's what's being reported at the moment. Whether that's true or not, we don't know. But and Also, could it be considered discriminatory, perhaps on the grounds of nationality? Have they only sacked their British staff? Remember, there are about 3,000 staff, but only 800 of them have been dismissed. If we're looking at the fire and hire side of things, because you want to fire people and re-engage them on a more favourable contract to you in terms of perhaps reduced holidays or reduced pay or whatever, it's always considered by those of us in HR as the nuclear option. But even if you go down that route, there should always be a consultation beforehand and not be issued as a fait accompli. And then, of course, failure to submit Form HR1. This is the form that needs to be sent into government for whenever you're contemplating more than 20 dismissals. And failure to do that can lead to criminal prosecutions, and it's also very bad PR. So that is, you know, a real problem there. The P&O thing in terms of how it went. Remember, they had 800 people dismissed in a 3-minute pre-recorded video. They were told to leave the vessel immediately. There was no consultation, no involvement of the trade unions. They brought in security guards, apparently trained in the use of handcuffs. And they've appointed a panel of legal advisors to sign off settlement agreements for staff at £250 per employee. So overall, it's not the greatest way of dismissing people. We'll have to see how it plays out, but it's not a method I would recommend. Now we're going to move on to some tips from the tribunal. As I mentioned earlier, I actually sit as a member of Tribunal, so I thought it might be helpful to give you a few hints and tips, things that I've noted that might help you to prepare for one if you've not done one before, or perhaps if you've not been at a remote or a hybrid hearing. So let's just have a look at these. Okay, so in terms of preparation, a little bit of background for those of you who are not familiar. Ordinary unfair dismissal cases or unlawful deductions for claims, very simple things like that, are heard by a judge sitting alone. A panel is required for discrimination and whistleblowing cases. So in addition to the judge, there are 2 panel members, one from the employer panel, so that would be somebody like myself, and one from the employee panel. That might be somebody who is experienced in representing other employees, like trade union members, staff reps, maybe somebody who has experience working in a citizens advice bureau, that sort of thing. And we all have equal weighting for any decision that we make. So we try to get unanimous decisions wherever possible, but it is possible to get a 2-to-1 decision as a majority, and it might be that both panel members agree one thing and the judge agrees something else. If that's the case, that's how it goes, that the judge doesn't get a bigger weighting. In terms of how it starts, firstly, you're likely to have case management hearings beforehand with judges alone. These are things that would normally agree to the list of issues and any matters arising. So that's really saying, what is it that you're asking the tribunal to decide? What are the facts that are disputed? What are the facts that are agreed? And what are the claims? So it's more of a sort of structure for the tribunal panel to see. It also covers things like, well, how many witnesses are being put forward so that the tribunal can be scheduled, you know, how many days is it likely to take to go through the evidence. And it'll also agree deadlines for when the bundle of documents for evidence will need to be put together. Case management hearings are usually held by telephone or video conference, and there's usually an encouragement to settle if possible. More judges are actually being trained to use judicial mediation to try and help parties to come to an arrangement early on, rather than having to go maybe through a week of tribunal hearings. Really important that you comply with the output orders from the judge. The judge will write to you afterwards and will set out what has been agreed and what will need to be done before the hearing takes place. For example, just last week I was supposed to sit on a tribunal, but it was cancelled because the complainant had not complied with an unless order. And what that is, the judge will say, this won't go ahead unless you do X, Y, and Z. The claimant obviously didn't do that, so it hasn't gone ahead. Similarly, that can apply to respondents as well, to the employers. On the day, if you've not been to one of these, beware that the tribunal does not get the bundle until the beginning of the first day. If I turn up for a tribunal hearing, I have no idea what the case is about. I don't know who the people, well, I've got an idea who the names of the individuals are, but I don't know any more than that. I will be given the bundle of documents when I turn up. So the first hour is often spent agreeing things like the order of the witnesses, what the timing constraints are. So, for example, if you've got a witness that can only appear on one day but is unavailable on other days, that's the time to tell the judge so that things can be structured around that individual if necessary. Although quite often they may say, sorry, you've got to make yourself available or you don't appear. Then we'll have time set aside for panel members to read the documents. That might be an hour or two. It might be longer if it's a very long case. So short cases may start witnesses maybe late morning, early afternoon. Longer cases, you may not actually start giving evidence until the following day. Depends on how much evidence there is to look through. But remember, the panel will not normally read the whole bundle. And sometimes we get 3 or 4 lever arch files full of stuff. We will start reading the ET1, that's the claim form from the claimant, the ET3, that's the response form from the employer. We'll read the case management hearing orders from the judges involved previously to see what the list of issues agreed issues is, and we will read the witness statements. That's where we will start, and that's normally where we will stop. If you want us to read anything else, you need to make sure witnesses refer to those documents in their statements. That's considered the prime evidence. And you can't just, there's no point in just throwing stuff in there because it looks useful. If it's going to be pertinent to your case, put it in. If it's not, then why is it there? Think about that. But bear in mind, you put documents forward and also the claimant will put documents forward as well. So there may be stuff in there that you didn't necessarily think was important, but they did. Really, really important, please, please, please make sure your bundle page numbering complies with the tribunal instructions. And that is both manual and electronic. We use PDF software. So if somebody says go to bundle page 5 and we go to bundle page 5, but actually you've thrown in 4 pages of indices at the front but haven't included them, we'll end up on page 1. So it is important that actually you make sure that the numbers on the pages actually are the right numbers, because otherwise there will be chaos. Please also separate out witness statements from the main bundle and make sure all witnesses have access to the documentation. That's really important if there's a virtual hearing, because they need to be able to see the bundle as well, because if the barrister from the other side says, please turn to page something or other in the bundle and they haven't got a copy of it, that's going to be a little bit awkward. It's not impossible, but it slows things down. If you're dealing with a virtual hearing or a hybrid hearing, what we've been using so far is something called CVP, Cloud Video Platform Software. It works well with Google Chrome, but not very well with some of the others. So please make sure that you use that browser in preference. We find sometimes we have individuals who perhaps are using Apple devices. They click on it, goes to Safari with a link. What you need to do is make sure they've got Google Chrome loaded and then take the URL and paste that into the browser so that they get the right link. Also check your computer is plugged in and switched on. By that I mean charging. And make sure you've got a good microphone. That is the biggest problem we've had, is that people's microphones haven't been good enough, and it's been very difficult to hear people. And the other thing is, if you've got earpieces and they're iPhone earpieces, don't plug them into a non-Apple laptop because they're not compatible and it just makes a horrible noise. use some reliable microphone or a decent speaker and microphone. Oh yes, if you're using a conference room with a laptop connected to a screen on the wall, so you might have a good system, please only have one speaker connected, because you end up with a terrible echo and feedback. And if the sound quality is poor, the judge may switch to telephone conference for audio. So you turn the audio off on your computer and just use the telephone. But don't do as one of our claimants did. So yes, I can do that. Judge uses his mobile phone, but only has 7% charge and doesn't actually have the charger with him, and has to then stop for half an hour to go to his partner's house to go and get his charger, to come back again and plug it in. So it's really about being prepared, and make sure your witnesses are aware of all those things too. And now I think I'll hand back over to Sue.
Hello, thank you, Helen. Thank you very much. Very interesting, isn't it? There's a lot going on, isn't there, at the moment, legislation-wise. So we're now going to have a look at a recent update in law, and then some of the bills working their way through Parliament currently. And then finally, we're going to look at some of the consultations of interest that are due to close very soon. So that's our next kind of topic. So firstly, let's look at the some current legislation and some bills going through Parliament. So we have recently had the Health and Social Care Act 2008 Regulated Activities Amendment Coronavirus No. 2 Regulations 2022 Act implemented rather urgently. And this came in from to effect from 15th of March, so last week, that revoked the original requirement for employees and workers to evidence their COVID vaccination status when working in the health and social care sector. The implications being that if they could not evidence their vaccination status, they would not be able to continue to work in the health and social care sector, because they'd extended the requirement for compulsory vaccinations from nursing homes only to the wider sector from April. So a number of employers in that sector had been going through a consultation process to encourage staff to be vaccinated where they could, and for those who were unable to be vaccinated or couldn't, they were having to go through a consultation to advise them their employment wouldn't continue beyond April if they were still unable to evidence their status at that point. And it all was on the back of the government. If you remember earlier in the presentation today, we discussed the fact about a reasonable and proportionate means of achieving a legitimate aim. The aim of the government in introducing this was to restrict the transmission of the virus. But as we've progressed, they believed it no longer was a proportionate response to still a legitimate aim of reducing the risk of the virus spreading. So they have revoked that requirement, and so now they don't need to see the evidence of a worker's COVID vaccination status, which should help significantly with the recruitment challenges that we're going to face as well come next month. So that's just the one significant act being implemented urgently recently. We've then got the employment bill. This has been on the on our sort of sites for a couple of years now. It is still expected to be passed this year, although it's still only at the second reading stage in the House of Commons at the moment, and it still has to progress several more stages in the House of Commons and then the House of Lords, and before it's ultimately enacted. So this contains a number of quite significant proposals that we need to kind of be aware of and sort of keep an eye out for. So they're thinking of introducing a new single enforcement body to protect several key employment rights for workers. This is, for example, enforcing national minimum wage and holiday pay for vulnerable workers. Also, a new duty on employers to prevent workplace harassment. an extension on redundancy protection rights for pregnant workers. Currently, this is only for those on a period of maternity leave, but this is set to be extended by a further 6 months on return to work, plus the right to be given priority in being offered a suitable alternative role. So some quite significant changes on the horizon. There's also a right, looking at the right to ask for flexible working to become a day one right, and introducing neonatal leave and pay, which would be a new statutory entitlement for up to 12 weeks paid leave for parents of babies who have spent at least 7 days in neonatal care. Then there's workers to receive tips in full and an entitlement to 1 week's unpaid leave for carers. There's also the status of worker bill. This would create a single worker status. Those of you who will remember the Pimlico Plumbers case that's quite recently gone through all of its various stages, that case actually started being a case about worker status, whether they were self-employed or whether they were actually workers. But there are currently 3 statuses. There's a worker, an employee, and a self-employed status. And the aim is to reduce it to just 2 categories of workers: those who would have employment rights for day one of employment and self-employed. So it would make it much clearer. You either are one or the other. But status, as you will be aware, is still really key in determining what benefits a worker or employee is entitled to, and from a self-employed perspective, ensuring that they are not being treated as a worker or employee under the current categories, and they are genuine self-employed. We've then got the Bill of Rights. So the consultation for this has been extended until the 19th of April. This bill would then restore the proper balance between the rights of individuals, personal responsibility, and the wider public interest, and would then ultimately replace the Human Rights Act 1998. So quite a significant change there, because the Human Rights Act is a significant and important piece of legislation that's been in place for quite a long time. And then finally, in this section on the bills going through Parliament at the moment, we've got the Police, Crime, Sentencing and Courts Bill. And part of that is they're looking at reducing the time for certain convictions to be spent, meaning they're not automatically disclosed on employment checks. There would be some circumstances when they wouldn't apply, for example, in serious sexual, violent or terrorist convictions, and where the sentence was 4+ years. But clearly on our right to work checks and in our recruitment processes, that could be for some roles quite an important change. And then finally, there are a few consultations going through that may be of interest to you. So we've got the umbrella companies and the role they play in the labour market and how they interact with the tax and employment rights systems. That one closed in February, so we're hoping for an update on that shortly. Another one that closed in February was the Home Office Code of Practice for Employers. This was to help employers prevent unlawful discrimination when recruiting. Then we've got a couple that are not closing yet. We've just spoken about the Bill of Rights, which has been extended till the 19th of April, but we've also got the future skills requirement for those operating in the transport sector, and this should hopefully help boost diversity, improve training and employment opportunities, and promote careers in transport, obviously a sector that's been challenged significantly recently. So that's all the kind of legislation section. Because we've had a number of inquiries through our helpline and through the consultants team recently, a lot of employers are looking at how they can help as an employer, how they can help their employees who are going through various challenges. So there are 10 kind of points that you could consider supporting the cause at the moment. So first of all, you may need to identify any employees who may need help. We suggest this is a company-wide communication and avoid singling out any particular ones to avoid discrimination. So you address any communications to the whole workforce, and then those that need support will respond accordingly. So remind all employees of any employee assistance program you offer, or if you don't operate one, perhaps signpost employees how they can access counselling and advice externally. If you do provide mental health first aiders in the workplace, ensure that all employees know who these individuals are and how they can be contacted. For those who have family members in the Ukraine, can you offer time out of the workplace to help them support their family member in making necessary practical arrangements for leaving the Ukraine? This could be paid or unpaid, and we suggest providing how much time out you are happy to support so you can effectively manage the absence. You could also, if you do employ Ukrainian nationals on a visa, hold individual supportive meetings with them to understand any implications the crisis may have on their visa, especially if there are visas which are due to expire imminently. We suggest contacting the relevant authority. We've got a further information section coming shortly, which you'll receive when you get a copy of these, of places you can go to for advice on your particular situation. Then you might have employees who wish to take time out of the workplace to go to Ukraine to fight. This is challenging because the Foreign Enlistment Act makes it unlawful for a UK citizen to fight for a foreign power at war with a state the UK is at peace with. So while you can make decisions as an employer about any time out from the workplace, you can't advise on any legal implications from their actions. So we'd encourage you to direct your staff to official channels to fully understand the implications and if it would lead them to committing a legal offence, because some may not be aware of it. Communications with those who are directly impacted should be supportive and frequent so that the individual feels fully supported and the line manager can anticipate any further needs that they may be required and any help or support they need in managing their workload if necessary. Employees may also be wanting to take personal steps to help in the crisis, whether this is to donate emergency supplies or money or time to volunteer. It may be helpful to your workforce to know of where they can take any unused items for donation or how they can make a financial donation. If you offer a company policy that supports people to take part in charity work, remind your employees of this, as they may wish to participate in charity work to help with the collection of resources for refugees, for example. But do keep up to date on developments as they unfold, because while these steps may be appropriate at the moment, the situation is developing and there could be different aspects that have a greater impact on UK employers and employees, and that may necessitate different or further support. And we're also hearing of companies rescinding their ties with Russian-based companies. That decision's obviously unique to each business, but also consider if you have any Ukraine-based companies that you work for or with as well that may need your support. There are quite a lot of sources of information. We've listed a few of them here. For kind of the government advice, Ukraine foreign travel advice. There's also the Ukrainian Institute in London, which shows how you can provide support in case of interest. So that's the end of our kind of presentation of information now. We're actually going to move into our question time. So we have had one or two questions. Sorry, I think my mouse has got a mind of its own today. That we've been asked. So Helen, are you around? Can we perhaps have a chat about one or two of these?
Yes, I am. Perhaps the easiest one to do is to start with the last question that was asked by Claire about the IDVT technology. And this is Claire Norton. She wanted to know whether it would be a charged service. I've just been doing some digging around on this, and apparently at the moment there's no guidance being given on that. So we don't know is the sort of the brutal answer to that one. It doesn't provide any, the updated guidance doesn't provide any cost information. So we'll have to wait and see as to what happens with that one. But then if we sort of move back, we've got questions on COVID. So Katie wanted to know if an employee tests positive but has no symptoms and is happy to work, but we don't want them to come to work or unable to work remotely, do we have to pay them full pay if we're insisting as an employer that they must remain at home? Marianne Cheney, unfortunately she's left, but she asked something very similar. She wanted to know if someone could claim unlawful deduction if an employer requires isolation after testing positive because sick pay is SSP and the employee is unable to work from home. So those are two very, very similar points. And I think from my perspective, I think the answer is it depends what your policy is that you've got in place to start with. If the policy is you must, if you've tested and you're positive and you can't come to work and you must stay at home, then that's one thing. But if you try and make it up as you go along and there's no policy before an employee falls sick, then you're asking them to stay at home, and yes, you'd need to pay them. Sue, what are your thoughts on that one?
Yes, we've had this debate recently, actually, and I think, yes, you would have to pay them. It is easier if you've got it clearly defined in your sick pay policy, but there is the point that employer may not be presenting symptoms, but if they've tested positive, then they are infected. So therefore, they are sick, technically. So sick pay rules would come into play, potentially.
Yeah, I mean, it's a little bit like those people working in sort of catering or care facilities, whereby the employee has sickness or diarrhea, they're required to stay off work for 48 hours after the last episode of sickness or diarrhea. And in those cases, the employees would be paid sick pay rates. But that's a requirement, and that's stated in the policy to start with. So I think the key bit is having the policy in place so that employees know where they go. I mean, the other thing, of course, to bear in mind is HMRC are no longer reimbursing people who are off sick, employers to claim SSP for people off sick with COVID, and the first 3 waiting days are no longer payable. So there is this push by the government to say, well, actually, we're going back to normality, and this is ordinary sick, and this is what's going to happen. But of course, from April, there will be no free tests available. So you can't insist that an employee can be must take a test unless you provide one for them. They won't be able to access free tests anymore.
Yeah, and there's a whole host of people who are looking at releasing tests that can be purchased by employers for that very reason. So can buy them in bulk for obviously cheaper than you can go and buy a pack at Boots or something. So it is an issue, and it is a challenge, and it's one of those typical grey areas, isn't it? Until it's tested,
yeah,
we won't actually know. But I think I would hesitate on be cautious and follow sick pay rules, and if you're insisting they're staying at home and you can't provide them with work to do at home, then that is the challenge, because your risk assessment was potentially saying you don't want them to attend work because of the risk.
This might, of course, be a situation whereby you've got other clinically extremely vulnerable people at work, and you might have put your policy in place to say, if we have somebody who's tested positive, we will not allow them into the workplace to protect worker A or worker B or whatever that might be. It might be one of the reasonable adjustments that you put in place. Alternatively, if you let the person who has tested positive but is showing no symptoms into work, it may be that you ask the clinically extremely vulnerable people to work from home for a few days whilst you know, that's the other option. So it is about your risk assessment. It is about making sure your policy is extremely clear and that employees know what happens in certain situations. I mean, once the testing regime stops, if you don't insist on it, nobody will know that they're infected if they have no symptoms. Won't have done a test.
Absolutely, and I expect that's how it's spreading so quickly at the moment, is because people don't know they've got it until they actually present symptoms. Unfortunately,
it's one of those things that has been left rather vague, because the government has said, well, we're taking away the legislation, but we recommend that if you're poorly, you stay at home. It's left the decision fairly and squarely on the employer's shoulders. So I think rather than vacillate, it's important that you actually decide what your policy is, make sure it's written down, make sure it's communicated to employees, and tell them what date it comes into effect from.
Yeah.
So they've got prior.
And they've got the opportunity now, with the changes of testing arrangements and everything, from April to actually implement something that that is the logical date is to implement it from April, when they remove the free tests.
Yeah. So, Katie, I hope that's answered your question, albeit perhaps somewhat vague. Gives you an idea of the issues that we're juggling with.
One day, something to do with COVID will be clear and cut, won't it?
Well, historically
no, probably not. Yes. Yeah. So I think that's all the questions, isn't it? So thank you very much for that, Helen. Thank you for your help with that. If you do go away from this and kind of have some burning questions, then do message us on Inquiries At, or if you're a client, via your normal channels, and we'll be more than happy to help respond to them afterwards. We always welcome your feedback. We will send out a short survey to capture this. It'd be really appreciated if you could let us know what you think, because we want to constantly improve. And if you have any thoughts about whether we should revert to face-to-face seminars in the future, let us know. We decided that actually this year it was still too soon, and actually with the current challenges we're having, even with our own staff, quite relieved we did keep it virtual this year, but we do keep it under review. Just to let you know, we have got some upcoming webinars. The next one's about share and share option schemes. Following the Great Resignation challenges of this year, people are looking at different ways of retaining staff and providing better benefits and more options. So we're looking at share and share option schemes with one of our partners. Then we're also looking at the disciplinary process, how to write legally compliant conduct allegations. That's an extremely popular webinar. There's already hundreds of registrations for that one. So clearly we've hit a kind of useful, interesting topic there. And then as part of our health and safety range, we've got an introduction to food safety in April as well. But there are many others, and we're about to post the next quarter's webinars as well shortly, so keep an eye out for those. All of our historical webinars are kept in an archive. They're available on our main website, and those of you who have knowledge base access has access through there as well. This is just an example of some of the topics we've covered recently, but there's those and many, many more. So do have a look. They can be useful kind of reminders and checklists if you're going through any of these processes. If you're interested, we do cover a wide range of management and health and safety training. This is some of them accredited. We do the ILM leadership and management training, and a number of health and safety accredited training courses as well. For those of you who are not a client, we do have a resource for HR staff and line managers. This is a knowledge base. It's an online resource giving you access to lots of template documents. So to save you starting from scratch, we've got a whole load of them you could use as a basis. So do let us know if you're interested in that, and any of our other services. So finally, it remains for me to say thank you. Thank you to you all for attending and for your really interesting questions. Thank you to Helen for a very interesting insight into the tribunals and covering some of the cases that are ongoing at the moment. So thank you very much. We hope to see you again soon on some of our webinars and in the future, perhaps face to face, who knows. Thank you very much.